last occasion we were discussing about the securities collaterals. Before that, I just want to have a small clarification, because the last occasion one student asked me whether I'm going to discuss bills of exchange and checks. I just want to know whether I have given that note before. Have you received that note? Can someone respond to me? Can you please, can someone please respond to me?
Yes, sir. We have received negotiable instrument due.
Okay. So that, when was that? I didn't start that, no?
Yes, sir.
Right. Okay. So then, actually, that I will discuss after this one, and also there is another one that I am going to discuss, that is debt recovery law. Most probably, the checks and negotiable instrument will be discussed by another lecturer. I will discuss with him, and if he is going to cover that part, then Mr. Ranga will continue their own words. However, if he is not going to cover the negotiable instrument and checks, then I will take that part also. Just for the moment, keep that part away. We'll finish these securities, and then thereafter debt recovery law. Clear? You are okay with that now?
Okay, sir. Thank you.
Right. Okay. So then we'll start from here. We were discussing about last occasion. We discussed about the immovable properties and movable properties. We had a comparison on that, and then we were discussing mortgages on immovable properties. The immovable mortgages or mortgages on immovable properties, lands, are governed by Act number 6 of 1949, Mortgage Act. You may remember we discussed that, and this act has been amended in several occasions. However, the main act is number 6 of 1949. I said when we are getting a mortgage on a land, first we check the title of the property. We see whether the mortgagor has a right to mortgage the property to the bank. So that we checked at the land registry, and a lawyer prepare a report. That report is called title report. After searching the title at the land registry, he prepared the title report. Then the next step that we want to see whether the property has enough value to secure the facility. For that, we take a valuation report. The valuation report is prepared by a valuer. We have panel of valuers. Then we get a valuation report from him, and we have a market value. We get a market value and the for sale value of the property. So basically, we consider the for sale value for a loan, and or some banks, they consider the market value also. However, we give a percentage, not 100%, maybe 70 or 60% of the market value we lend, because we keep a margin there, because to cover the interest and the expenses, we keep a margin. We don't give 100%. There are occasions that we give 100%, but normally we don't do that. Then I said thereafter we have to get an inspection report. The inspection report is to be prepared by the bank officers. They have to visit the location and identify the place, the land, the boundaries, and you have to see who is in the possession, whether the owner or somebody else in the possession, and also the right of way. All these things that you have to observe, and you have to prepare an inspection report. And then thereafter, we have to get local authority certificates from the owner. That is ownership certificate, non-vesting certificate, and street line and building line certificates. So then, apart from that, we need an approved plan for the land, and also if there is a building in the property in the land, we need a building plan, approved building plan also. And if it is a residential property, we want to get the COC, or even a business premises, we have to get the COC, certificate of conformity, from the relevant local authority. Then, if it is a loan to build a house, then we get a BOQ, bill of quantity, and you are aware that if the loan is for the purpose of construction, we release the loan stage by stage. So that is how we grant loans for construction purposes. Then after getting all these things, we then execute the mortgage bond. Together with the mortgage bond, we get Section 47A declaration. Section 47A declaration, I believe that I explained last week. That is under Section 47A of Mortgage Act. Then, after obtaining the mortgage bond and the declaration, we have to register the mortgage bond and the declaration at the land registry. So that is important. The registration gives the priority to the document that we register. So you may heard this sometimes, some occasions, the customers, they mortgage the property to more than one bank, or sometimes they mortgage the property to the bank, and then thereafter they can, without the permission or without the knowledge of the bank, that they can mortgage the property to somebody else, or they can even transfer the property. So the question is then what will happen to the mortgage, whether we get a right or priority over the other documents. So it all depends on the registration. If you register your mortgage before the next document, we get the priority. If the other document is registered before our mortgage, so that mortgage transfer deed automatically get the priority over our mortgage. So it is, remember, sometimes you may get a primary mortgage, then if there is another mortgage is registered, then of course if our one is mortgage first, our one is considered as a primary mortgage, the other one will be considered as a secondary mortgage. However, if our mortgage get registered after the second mortgage, irrespective of the wordings there, it could be a secondary mortgage. However, if it is registered before our mortgage, then it get the priority. So that means even though that document is called secondary mortgage, it under the law it will considered as a primary mortgage. Then our one will be a secondary mortgage. Secondary means subject to the previous mortgage. So therefore, it's very important the registration of the mortgage bond. Then there is another important thing that we have to remember as a bankers. You may aware now in certain part of the country, there's a program is going on which is called BIM Savia, or in English we call this title registration. So in future, what will happen? These deeds will not be exist. So basically, like in other countries, Western countries, now what we are doing, we are issuing a certificate, ownership certificate for the lands. So that document is called title certificate, or in Sinhala we call it BIM Savia certificate. So that certificate gives the the title to the property. So this program is going on now in certain areas of the country. Now they have already issued title certificates. So remember, certain areas, if it is under Binsavia area or title registration area, the customers, they don't have a title deed, they have a title certificate. So they are also the same thing that we have to check the land registry or title registration office, which is in the same location in the land registry, and you have to prepare a title search. So there is the understanding, or there is the idea that you think that if you have a title certificate, and then the title that you don't have to check because the title is good. It is not correct. The title can be subject to certain conditions or certain encumbrances, or there can be leases or mortgages registered. There can be a lot of encumbrances in the title of the property, even though the title certificate says it is a first class title. So therefore, just because that they have a title certificate with first class title, it doesn't mean that we can do away with the title search and title report. So always, and my advice is to get a title search done and also get a title report from a experienced lawyer. So then in the title registration area, that we don't have survey plans. The private surveyors, they don't prepare plans for the land. Instead of that, we have a plan called Cadastral Map that is prepared by the Registrar General, the Surveyor General Department. Surveyor General Department, they survey the area, survey the land, and they prepare a plan which is called Cadastral Map. So the title certificate, Cadastral Map is important when you are granting a loan on a security mortgage of a title registration area. Then the other important thing is that I said that we have to get approved approved plan. Cadastral Map or the map prepared by the Survey General Department, you can't get approved that document from the relevant local authority. So therefore, what we do, based on the Cadastral Map, we ask the client to prepare a separate survey plan by a private surveyor. So then the surveyor will prepare a separate survey plan, and that survey plan, the customer has to submit to the relevant local authority and have to get the approval for that particular document. So it is important to have a approved survey plan. In my next slide, I will explain you why it is important. Then after obtaining all these, we can execute the mortgage instrument for a title registration area property. So that's a separate document that legal officers, they know what that document is. The mortgage, instead of the mortgage bond, in title registration areas, we execute a document called mortgage instrument. So that is how we get a mortgage over a land. Then what if we get a company-owned property? Borrower and a borrower is a company, and the company mortgage the property. What is the procedure that we have to follow? The same procedure we have to follow. So that means all these steps that we have to follow. And apart from that, there's another important step that we have to follow if it is a company. So then we have to, after executing the mortgage bond, that we have to submit a document called Form 12, that is certificate of charge, to register the charge in the ROC, that is registrars of companies. So if it is a company that you remember, apart from the title registration or deed registration at the land registry, there is another important document that you have to register at the registrar of companies. So that is the procedure when it comes to a company. So that's how we obtain a mortgage over a land under the Mortgage Act. If you have any questions from here, or if you want any clarification, you can ask ask now. Anything with regard to the mortgages, land mortgages, or title registration. Any questions?
Sir, when did this title certificate given has been started?
Can you repeat the question? You asked when title
Just
registration.
registration, they have issued now. They have started to issue the title certificates now.
Yes.
So when it has been started?
Yeah, okay. They started long years ago. That is 2011. They started. Actually, they passed the law. However, it is not covered the entire country. You know that certain areas they have completed. But for example, Komagama, they have completed certain Gramaniladari divisions. And Moratua, Ratmalana, they have started and they have completed certain area, Aptidia and certain areas that they have now covered, issued that. And Gampola, also Gampa, some areas they have covered, but not entire country. So it will take time. It will take another few years to complete the entire, to cover the entire country. However, in certain areas they have covered. So they started in 2011. You see now almost 9 or 10 years gone, but they have not completed, I would say, 1/3 of the country. So that is the situation. So it's very important. You must see the title registration areas are there. If title registration area, if the land is situated in a title registration area, it's a totally different process. It is not the title deed, it's title certificate, and the registration, and especially the title search. It's a different title search that we have to do. That the lawyers know that. However, you remember there are two registration systems in the country with regard to the lands. Clear? Any other question?
Excuse me, sir.
Yes.
There's a question. It means in a title registration area, if we want to get a approved survey plan, prior to that, we have to get the cadastral map, is it?
Yes, that is correct. Basically, what will happen when they issue the title certificate, after we get the title certificate, we have to get the cadastral map from the registrar. Survey General Department. Separately, you have to pay for that, and you have to get the plan that is called cadastral map. That cadastral map you can't get approved from the Pradeshia Sabha or municipal council or wherever. They don't accept, they don't basically approve that plan because it is another government institution issued plan. So therefore, what we have to do, the customers have to do, they have to prepare a separate survey plan by a private surveyor based on the cadastral map. They prepare a separate plan with a plan, a number, date, and everything, and they sign, and it's like a normal plan. So that plan, which is a duplicate of the cadastral map, we give to the Pradeshia Sabha and get it approved.
What will be the minimum land size in terms of perch in order to get a approved survey plan?
Good question, and it's different from place to place. If it is a Colombo Municipal Council area, even I think 2 perches or even 1.5 perches you can get approved. But in certain areas, for example, Nugegoda, it's 6 perches minimum. In certain areas, if you go to Homagama, again, I believe it's 8 perches. I'm not sure about that, but it depends. In that particular area, the local authority decide what is the minimum the purchase. Number of purchase need to be included into the plan to get it approved. It is not one particular rule in all over the country. Based on the sub rules issued by that particular area local authority.
Okay, thank you, sir.
Any other questions?
One more question. Now, let's say in case of a land acquisition, let's say I have 10 perch. Out of that, the government has acquired about, let's say, 6 perch. Then I have only 4, right? So now, if the minimum requirement is, let's say, that land is in Nugegoda, then the minimum requirement for survey and registration is 6 perch. Then I have only 4 perch now for the moment. So now will it be a barrier for the registration because this is under special circumstances of acquisition by the government? What is the process, sir?
Yeah, good question. Yes, it will be a barrier because the local authority, they have a rule there. If they say it is minimum is we say 6 purchase and now you have only 4 purchase, you can't get the survey plan approved. So then, for the property that acquired by the government, you get compensation, and the rest you can't get approved plan, but you can build those. The thing is, that building or the construction, you can't get a COC or even approved building plan. In that case, that means that you can't get a loan from a bank. However, the local authority, they can pass a special resolution in a case like this to pass or approve the plan. That is also possible. So that means that they deviate from their normal rule and they consider this as a special case and can approve the plan, but it has to pass by the council as a special resolution. Clear?
It's clear. Now, let's say in case of let's say now it's after 20 years or 15 years, can they consider this as an unauthorized construction? If it's not approved by no resolution, no special resolution, nothing like that, the survey plan is also not approved after constructing the building, let's say after 15 years of time. So can they consider this as an unauthorized construction because no approval, no?
Yes, can. It doesn't matter how long you are there, how long the building, how old the building is, unless it is approved and COC is given, it is an unauthorized construction. So
I mean, in case of this land acquisition, now let's say now I have only about 4 perch now for the moment. Yes. So I have constructed without the approvals. Now no approval given because I don't have 6 perch minimum requirement. Now yes. I have invested and constructed the building. So yes. Let's say now after 20 years or 15 years, right, yes. from the date of construction. So now there are so many policy changes, government changes, so many things. So can they consider that particular construction as an unauthorized construction because it was done under special circumstances? So it's a special case.
Yeah, but as I told you, before you start the construction, it is your duty to get the plan approved, the survey plan. So under special circumstances, the local authority can specially approve this particular block of land, even though it is below the minimum requirement. So if you have constructed on a property with on a property where the plan is not approved, and the construction, the building plan also not approved, that is legally, if you see, that is an unauthorized construction. So that is not an exception. You can't say that because of special circumstances I didn't obtain the approval, and therefore now it is you have to consider we were there for 20 years, so therefore it is approved. No, it is not approved. You know, there are places build the business premises, and you may see that they come and they destroy the places if those are unauthorized constructions. So basically the customer, I mean the landowners, they go to courts, but very rarely they can get a chance, because only thing they can ask is a compensation. Other than that, it's actually unauthorized construction. Clear?
Thank you very much. Thanks a lot.
Yes, any other questions from here?
Excuse me, sir. There's a question.
Yes.
When we go for a land mortgage, let's see, the mortgage which we are getting is we have to go through a street. The street should be, what is that length of the street? Sometimes the vehicle should go and turn. There is some sort of arrangement in regard to the law. In regard to the law.
You mean the width of the...
Yes.
Yes, okay.
That's the important thing, because so many in some areas, the mortgage land is a very high value and a very graded one. But when it see the street and all, as due to the width, it has been rejected so many times.
Yes.
What is the
yes. Okay. A very good question, right? As a banker, I told you that you have to inspect the property. So then I said one of the most important point that you have to mention in your report is the road right of way. So you have to, it is not the length, you forget about the length, it is the width of the road that you have to consider. What is the width? Is it 6 foot, or is it 10, or is it 15 or 20? So it gives a value to the property. You see, if this is the only property which serve this right of way, even 6 feet wide road is enough, because only that particular block has been given the access from the road. So therefore no vehicle will be parked on the road, only these people use it. So therefore you can consider that as a good access. But if there are many houses in this road, if you have 6 feet wide road, then it will be a problem. So that you have to remember. So in your report that you have to mention. That's number one. Number two, when we get the approval from the Pradesh Sabha or local authority, they put conditions, right? If it is one block, of course, then they say this is the minimum. They have rules. They say minimum width should be 10 feet. So in that case, they have to maintain 10 feet road. Or otherwise, if there are many houses in the road, so they have to give a turning circle, and there are conditions that they can put in force by the local authority. So unless that the requirements are met, the local authority will not approve the survey plan. Now, for example, we take a land sale project. When they are approving the plan, they put conditions. They say that you have to give say 5% of the land for the public use, and draining system must be there, the width of the road must be this much. Likewise, they can put conditions. Likewise, when we get the approval from the Pradesh Sabha or local authority, they have their set of rules. One of those rules are the width of the road, and also a number of people who use the road they will consider, and they can put conditions. Most important thing is whatever mentioned in the plan, you have to, as a banker, you have to go visit the location and you have to write your own inspection report. The number one, the first item of your report should be the right of way. You have to measure the width, you have to mention it, you have to see how many houses are using this, and likewise you have to write in your report. Clear?
So, sir, the width is decided by the particular local authority?
Yes, correct. Yes.
Okay,
Yes.
sir. Thank you. Thank you.
So then we'll go to the next one. If you have no questions more. Right. So this I have shown here is an approved plan, right? It's an approved survey plan. You can see some of you may familiar with this. You see the surveyor's name is there, surveyor plan number is there, date is mentioned in the bottom right hand corner. You see sometimes you see there can be two dates in the plan, so they put surveyed on this date and then they put a date and site. So the date of the survey plan, you consider the date the survey site, not the date that they survey the land, right? That is another important thing that you have to remember. And you see now this has been approved by Komagama Pradeshiya Sabha. So you see the approval seal is there, and it has been approved for the purpose of residential. So remember, if you are getting a plan approved for the residential purpose, that cannot be used as for the business purpose. So then you have to see for what purpose that this loan is taken. If he is going to put up a commercial building in this property, you see the approval is given only for the residential purpose. So then you have to consider that and you can't give this loan for that particular purpose. So he can purchase the land, but however he can't build a business premises there. So that is very important, right? And you see they have put conditions. This Homagama Pradeshiya Sabha has put conditions. There are 3 conditions there. It says Pahata Sadhan Kondesi Walta Yatatwa Salasma Anumata Karami. So its approval is given subject to conditions. What are those? Number 1, Uturuha Naginhira Kanu Sandha Adi Dekaka Rakshitaya Tabiya Yutuya. So you see there are 2 ditches on the north and east boundaries. So there is a reservation. So reservation that you have to give 2 feet along the north boundary and also east boundary. So that is a considerable area that you have to give up as a reservation. So reservation, you can't do anything in the reservation. So no building, you can't build anything, you can't use it anything. It's a reservation only. So therefore, when you are taking, now you see here that it says there are 2 blocks there. One block is 17.3 purchase, the other one is 12.4 purchase. So even though this particular plan says it has 17 purchase and 12 purchase, but after deducting the reservations, so the entire purchase will not be there. So that also you have to consider when you are taking this property as a collateral security. You see, even though it is 12 purchase on the plan, it could be 10 purchase after you reducing the reservation. So that one thing that you have to see, you just because the seal is there, my advice is don't take that as a approved plan just because seal is there. You see whether they have put conditions. Then the next one, number 2, පාරවල් මැද සිට අඩි 20ක ගොඩනැගිලි සීමාවක් තැබිය යුතුය. That means if you build a house or house there, then from the middle of the road you have to give 20 feet. Then only that you can build the house. So you have to keep 20 feet. Now, if you take lot number 200 in this plan, you see the west line and the west boundary and the south boundary, southern boundary, both are roads. Now you see, now you have to keep 20 feet from west boundary and also 20 feet from the southern boundary. So that means after giving that street line reservation, so there's a small space will be available for the construction. So that also that we have to consider if you are lending this customer to purchase lot number 200, or if we are getting a mortgage over lot number 200. So these things that you have to see when you getting a property. In your inspections also with the plan, you have to see this. You have to go visit the place and you have to measure from the middle of the road when you give 20 feet, how many purchase that you have to give up, or you have to give up for the building line. So that you can see those conditions are there. Then third one say පවරාගන්නා පවත්නා ගොඩනැගිලි මෙම අනුමැතියට යටත් නොවේ. So you can see there is a house in the lot number 199 house. So the construction that is an unauthorized construction. It is not approved even though the survey plan is approved. So if you are taking lot number 199 as a collateral, the property or the land, the building inside the property cannot be considered, or the value of the building cannot be considered because it is an unauthorized construction as per this. It is not approved. So not only that, then thereafter another condition put in the right hand side. 2011-10-20 දින ඇති සැලැස්මේ කමිටු තීරණයට අනුව බටහිර මායිමේ මාර්ගය සඳහා ගොඩනැගිලි සීමාව අඩි 20 සිට 15 දක්වා අඩු කිරීමට තීරණය විය. So after that they have reduced 20 purchase from the western boundary to the 50. So basically from the western boundary, the straight line now it is 15, but the southern boundary 20. So these conditions that you have to see, there can be several conditions, many conditions that they can put. My advice is just because the seal is there, approved seal is there, you just can't blindly accept the plan. You have to see the conditions and see whether it is good to take this property as a collateral. So any questions on this one? I think it's very clear. So then this is the cadastral map. I said it's not the same one. It's a different one, a different land actually. This is the cadastral map prepared by the Survey General Department. You can see the seal in the bottom right hand bottom. Says Survey General වෙනුවට somebody has signed. So that is the cadastral map issued under the registration of title certificates. So this is the BIM survey area. They issue a plan like this, which is called cadastral map. You have to go and you have to obtain this from the Registrar General Department. So after that, This you can't just hand over, give to the local authority for the approval. They don't approve this one. So what you have to do is you have to give this to a surveyor. Then the surveyor will prepare a separate plan like this plan. They will prepare a plan for this one, and that plan that we can get approved from the local authority. So then they can put conditions, or if there are no conditions, that they can just approve that plan. That is the plan that we consider as approved. Any questions from these two? Okay, so I think it's clear. Right, then that is about the land mortgages. Then we go to the movable mortgages. Movable mortgages, example, stock in trade and vehicles, book debts, likewise, that we can consider those movable properties, and movable properties also can be taken as a collateral, can be taken, can mortgage to the bank as a collateral to obtain a loan. So what is the applicable law for movable property, movable mortgages? Same act, that is number 6 of 1949 Mortgage Act. As I told you, it has been amended in several occasions. The act number 6 of 1949 applicable. Then we'll take one example, one movable property as an example, and we'll see what is the procedure that we have to follow when we are taking a mortgage over a movable property. We'll take stock in trade, right? So what is the procedure that we have to follow? So the procedure could be a little bit different from the product to product, or the property to property, movable property to property. For example, if it is a stock, we have to take the stock. We have to value the stock. If it is a vehicle, we have to value the vehicle. Likewise, it depends on the nature of the property. The procedure could be little bit different, but we'll take one example and we'll discuss the procedure. We'll take the stock in trade. So then in a movable property, the ownership, you don't want to check at the land registry or anywhere, because the ownership that you can certify, you can get certified, or you can check the ownership by looking at the ownership document. So for example, if it is a stock, if the customer has purchased the stock, that purchase receipt is enough to ascertain the ownership. So ownership won't be a problem. That anyway that we the bank officers can ascertain the ownership by looking at the papers available with the borrower, with the customer. So then after ascertaining the ownership, then we have to see the actual stock available at the date of the mortgage. So therefore, we have to get a stock count at the date of the mortgage. Then we have to get a valuation for that. So we have to ascertain the value, market value of the stock. So for that, we get a valuation. Then if we are taking a movable property, stock especially, next we take a insurance. That is very important. The goods that we take mortgage can be destroyed for various reasons. Those goods can be perishable goods, or when we have to keep these goods in a warehouse. So it can be destroyed by flood, or it can be destroyed by fire, or whatever. So we have to, or natural disaster. So we have to cover that. We take an insurance. Then we after that, we execute a mortgage bond. That mortgage bond is a similar to the land mortgage, same type of document, where you sign it, you execute in front of a lawyer, and thereafter, after executing the mortgage, we register the mortgage, the movable mortgage also. Where do we register the movable mortgage? So the movable mortgages also, remember, we register at the land registry. No, even though it called land registry, there is a separate area or separate department to register the movable properties, which is called which is well known as a Chanchala properties or movable property department that we register. They have books for that. We register the stock there. Then if it is a vehicle, we take vehicle mortgage. Then apart from that, we register the document mortgage in the registers of motor vehicles, that is RMV. You know that in the book that they include the mortgageor's name. So that is how we take mortgage over a stock or vehicle. If it is a company-owned property, that you remember, we take the property mortgage, and after that we file Form 10 and certificate of charge of Form 12. So these two documents that we have to register, or we have to tender to the registrars of companies. That is very important. Within 7 days that we have to produce that document and register at the ROC, registrars of companies. So this is the procedure that we follow when we are taking a movable property mortgage as a collateral. So if you have any questions from here, you can ask. Do you have any questions?
So where do we need to submit this if it is a company-owned movable property?
Sorry, can you repeat your question? I didn't hear you the first part.
Where we need to submit that if it is a company-owned movable property documents for the registration?
Registration, there are two places that we have to register. If it is a company-owned property, movable property, stock or whatever, firstly that we have to register the mortgage at the land registry. There is a separate unit in the land registry which is called movable unit. There we have to register the mortgage bond. Apart from that, there are another two documents that you have to register, that is at the registrars of companies, ROC, registrars of companies, which is in Maradana, DR Vijayawardena Mawatha. So there we have to submit two forms, that is number 10 and number 12, which is called certificate of charge. We register there, that we have to register within 7 days from the execution of the mortgage. Clear?
Yes, sir. Thank you.
Right. Any other questions? Okay, so then we have completed immovable mortgages and movable mortgages. The procedure and important points we discuss. So then we'll move to the next one. We will take life insurance as a collateral. Life insurance also can be taken as a collateral, can be considered as a collateral to grant facilities. So life insurance, when we are taking a life insurance, what are the things that we have to consider? What is the procedure that we have to follow? What are the documents that we have to obtain from the customer when we are lending on a title insurance collateral? So life insurance policy can be assigned as a collateral. So life insurance holder, policy holder, can assign the insurance to the bank and keep as a collateral and take a facility against that collateral. So this is called assigning of that life insurance or insurance policy. the loan amount should be less than the policy value. So this is, I believe that you know that we don't lend 100% of the face value of the insurance policy. So we give a percentage, 70% or 80%, whatever the percent, it depends on the policies of the bank, each bank. However, normally we don't give 100% of the face value of the policy. So what are the documents that we have to obtain when we are getting a life insurance as a collateral? Number one, the insurance policy. That we know that the original insurance policy of the customer, we have to keep under lien in the bank. So we have to get the possession, the original document we have to get into our hand. Number one. Number two, we get another document called letter of set off. We get this letter from the policy holder. So we get this letter gives the authority to the banks to set off any account of the policy holder against the dues of the bank. So that we get that authority by getting this letter of set off. Then apart from that, we get another document called letter of undertaking. The letter of undertaking we get from the insurance company. So that is very important. This letter of undertaking says in case the bank demand the insurance policy after the maturity, the insurance company gives an undertaking to the bank that they will not give the money to the policy holder, they will directly pay the bank on demand. So that is that undertaking is given by the insurance company to the bank. So we take the letter of undertaking for that purpose. So then those are the documents we need to get a collateral or a life insurance policy. Then in case of default, the bank will definitely demand from the insurance company. Then under the letter of undertaking, the insurance company is bound to pay the bank directly. So insurance company then without any question has to pay the insurance value or the face value of the insurance policy to the bank. So that is the procedure, or those are the documents that we obtain when we are getting a life insurance as a collateral. So that's about life insurance. If you have any questions, you can ask there.
Excuse me.
Yes.
In case of a customer default, even it's a long-term insurance policy, the bank has to wait until the maturity, right?
It's like this, right? Okay, well, a good question. Normally, when we are getting a life insurance policy as a collateral, we take a matured insurance. That means the customer, if the customer has paid all the installment, then we get that life insurance, which is called matured life insurance. That is number one. There is another way. If it is not matured insurance, that means that he has to pay another insurance premiums monthly or annually. So then in that case, what we do, we get another agreement, we come into another agreement with the customer, and we ask the customer to put money into a cash build-up account. So then from that cash build-up account, we service the life insurance policy. So basically, the life insurance installment we pay from the customer's account. So basically, customer then has to pay two installment, that is loan installment separately, and the life insurance installment that he has to put into the cash build-up account. So basically, if either it has to be a matured insurance or it should be close to mature insurance. It depends on the policy, credit policy of the bank. Some banks, they only take matured life insurance. Other banks, especially private banks, they take even unmatured life insurance with certain conditions. Clear?
Clear, sir. And from the banker standpoint, this mortgage is it's a risky product, right? For the bank compared to other mortgages?
If it is a matured insurance, yes, it is risk-free. Then if all the documents are there, then you are basically 100. We can say 100% risk-free because the company insurance company will pay in case of default. That is there. If it is not a matured insurance, then you have a risk. If customer deceased, then we have a problem because then thereafter the money will not come to the cash build up account, and since it is unmatured, that we will not be able to get the 100% face value of the insurance policy. And you have to, before you get the life insurance policy, that you have to read the policy and see. Sometimes they say unless you have paid this much of installment or 75% or 90%, that the insurance company will not pay the insurance. Likewise, there can be restrictions, conditions on the insurance policy also. So therefore, it is important to read the insurance policy before we get the insurance policy as a collateral. So it depends whether the insurance is matured or not. If it is a matured, say, we can say it's risk-free. If it is not, there is a risk. Clear?
Yes, sir. Thank you.
Right. Any other questions? Right. So then we'll go to the next one. Shares of a company also can be taken as a collateral. Shareholder can keep his shares as a collateral to the bank as a security and can borrow against the shares. So first we'll see what is the risk that we are taking or the bank bear when we are taking shares as a collateral. Shares is a little bit share collateral is a I would say a tricky collateral because it's not like other collaterals. If it is a land, we know the price will increase or decrease. Vehicles, we know the price can increase or decrease. But the risk in shares is high because the share value you can't predict, right? That is the most important or most dangerous part when we are taking the shares of a company. So so shares of the listed company can be obtained as a security. Value of the shares fluctuate on market condition. That is very, very important. So it can be fluctuate. It can be fluctuate within a day also. It can be changed, right? So today, if you take the shares, we say today in the morning, the share of this company is 10 rupees, but in the evening, it could be 5 rupees. So it is the danger there. So then there should be a mechanism to review the market value of the shares. So bank, if you are taking this shares as a collateral, the bank should have a mechanism to review the share market and see the share, how the share value behave. So otherwise, what will happen? You are carrying or you are taking a high risk there. So therefore, it is very important to review. You should have a review the price of the shares or share market behavior. You should have the knowledge. You should have the technology to review this. There has to be a mechanism. And normally, when we lending on shares, we give only 50% of the share value as a facility. Now, for example, if we take 100 million worth of shares, we only give 50 million facility because it's high risk. So therefore, we keep a big margin, 50% margin there. So we keep a margin like that, when if you see the share value comes down regularly, then immediately the bank has to take a call and you have to instruct the instruct to sell the shares and get the money to the bank. So that's why we keep a big margin there, 50% margin when we are lending on company shares. What is the process and what are the documents that we have to obtain when we are getting the shares of a company as a collateral? Firstly, we enter into a tripartite agreement. So tripartite means 3 parties involved. So what are the parties involved here? The bank as the lender and the shareholder, that is the borrower and the mortgagor, and also stockbroker. You know that shares of a company you can't just sell in the market or open market, or you can't auction the shares that you have to sell in the share market. So share market dealings can be done only through a stockbroker. So therefore there has to be a tripartite agreement between the bank, shareholder and the stockbroker. So basically this agreement say banks lend money, that is the condition, and shareholder gives the collateral, and the stockbroker agree to adhere to the instructions of the bank. So that is the basis of this agreement. So when, in other words, when banks demand the stockbroker to sell the stock or the shares of the shareholder, the stockbroker has to sell that and give that money to the bank. That is the main idea of this tripartite agreement. Then after that, after entering into tripartite agreement, then bank obtain a mortgage, stock mortgage, that is share mortgage of that agreement between the bank and the shareholder. Mortgage execute between bank and the shareholder. Then apart from that, there is another agreement called margin trading agreement. So margin trading agreements that we sign between the bank and the shareholder. So they are the banks get the authority to sell the shareholders' shares in the share market as bank think. So then after that, the mortgage will be registered again in the land registry. So that is the procedure, and those are the documents that we obtain when we are taking listed company shares as a collateral. So if you have any questions, you can ask about share mortgages. Right. Okay. So then if you don't have questions, then I will go to the next one. Then we are going to discuss about the guarantees and indemnities. Guarantees and indemnity. The guarantee, in Sinhala we call this apakaraya. Indemnity we call this hani purna. Right? So guarantee and indemnity, remember, are not the same. These are two different collaterals or securities. So remember this. And this guarantee and the indemnity are governed by two different law principles. This is very important, right? Guarantee is this is a comparison. There's a simple comparison to understand the difference between the guarantee and the indemnity. So if you remember this comparison, then it will be very easy to you, because this is actually exam question. In several occasions they have asked this to compare the guarantee and indemnity. Right. So what is the difference between the guarantee and the indemnity? Guarantee is a secondary liability. Under the guarantee bond, the guarantor has a secondary liability. Secondary liability means the primary liability is with the borrower. If the lender cannot recover the money from the borrower, then only the guarantor's liability creates. So basically, the bank, if you lend on a guarantee bond, first you have to go behind the borrower, and if you can't recover the money from the borrower, then only that you can go behind the guarantor. That is number one, secondary liability. Indemnity is different. It's a primary liability. Primary liability means the indemnity under the indemnity, the surety gives the surety gives the indemnity to the bank as the borrower. So basically, his liability is same as the borrower. It's a primary liability. So that means in case of default, the bank does not want to go behind the borrower straight away, that you can file action or go behind the surety under the indemnity. So that's a one major difference between the guarantee and the indemnity. Guarantee is a secondary liability. Indemnity is a primary liability. Then guarantee should be in writing. So guarantee always it has to be in writing. Unless it is a written document, written signed document, the guarantee is not valid. So whatever the written in the guarantee will be the terms and conditions of the guarantee. Nothing else that you can apply. But when it comes to indemnity, it is not necessary to be in writing. So that means the indemnity can be in writing or without a written document. So that means verbally also you can give an indemnity, right? So that, but however, when we are doing business, when we are talking about the business commercial transaction, we don't take verbal indemnities, but day-to-day life, people get verbal indemnities also, right? Verbally, you can give an indemnity, and it can be, if you can prove that there was a verbal indemnity in court of law, so you can go behind the surety on the verbal indemnity. Verbal indemnity is legally basically valid. So, however, the guarantee only it is valid if it is in writing. So that is number two. Number three, the validity depends on the validity of the principal debt. If the validity of the guarantee bond depends on the validity of the principal debt or principal agreement. The other side, indemnity, the validity of the indemnity is independent from the validity of the principal debt. What is this? For example, if you lend money on a guarantee bond, you know, when we are lending a guarantee bond, guarantee is provided by the third party, right? The borrower signed an agreement with the bank, that is the loan agreement. Bank and the borrower sign this loan agreement, then thereafter the guarantor signed the guarantee bond. So these are two different agreements. But the validity of the guarantee bond is depend on the validity of the first agreement, principal agreement, that is the loan agreement. So it is like this. If your loan agreement is not valid in law for whatever reason, then even though the guarantee bond is properly obtained, the guarantee bond automatically comes null and void. So basically, you can't enforce the guarantee bond if the loan agreement is not proven in court of law. So therefore, it is very important when you are lending. Just because you have a guarantee bond, if you have lost the loan agreement, or if you have forgotten to get the signature of the borrower into the loan agreement, so then you have to forget about the guarantee bond also. So you can't go behind the guarantor unless you prove the first agreement, principal agreement. So that is about the guarantees. But when it comes to indemnity, it is different. Indemnity agreement is totally independent from the principal agreement. So if you have an indemnity, so then that indemnity will stand alone independently. So if you lose the loan agreement, or if it is invalid for whatever reason, the indemnity agreement can stand alone, and you can sue the surety under the indemnity agreement. It's not necessary to prove the loan agreement, the validity of the loan agreement there. So that is the comparison of guarantee and indemnity. Right. Any questions from this one? Okay, then I'll go to the next slide. That is the guarantee as a guarantee and surety. Guarantee or surety is a collateral by collateral of lending institutions. Guarantee is a contract. Now remember the guarantee. When I say the guarantee, it is a contract. So guarantees are governed by the principles of contract law. In a guarantee, there are three parties. That those are principal debtor, then the creditor, that is the lender, principal debtor, the borrower, the creditor, that is the lender, and the third party who gives the guarantee, that is the guarantor. So these are the parties in a guarantee bond. Then the guarantees are governed under the commercial law in Sri Lanka. The commercial transactions are governed by English law. The guarantee, remember this is very important, guarantee is governed by Roman Dutch law and Prevention of Fraud Ordinance number 7 of 1840. So even though the commercial transactions are governed by English law, the guarantee bond are governed by Roman Dutch law. Then section 18 of the Prevention of Fraud Ordinance says contract of surety must be in writing and signed by the surety himself. So otherwise the guarantee is not valid. So that's why we say the guarantee has to be in writing. Right. The guarantee, since the guarantee is a contract, the contractual capacity is an essential element. So this is very important. If you take a guarantee as a collateral, remember it is governed by Roman Dutch law and the contractual law principles apply. The contractual capacity is very important. So therefore, when you are getting a guarantee, you have to see whether the guarantor is, whether he is a minor or whether he has attained the age of majority. The minors cannot give the valid guarantee. If it is a person below 18 years of age, that guarantee then will not valid, right? Then as per some personal laws, married women cannot give valid guarantee without the consent of the husband. Example, Tesavalami law. This case, Thanga Ponnu versus George, 1949. This case decided the woman governed by Tesavalami law cannot give a guarantee without the consent of the husband. So basically, this what happened in this matter, that lady gave a guarantee bond and the borrower defaulted, and the company filed, or the company filed action against the borrower and also the guarantor. Guarantor took the position that his guarantee or her guarantee is not valid because she is governed under Tesavalami law. At the time of getting the guarantee bond, the company has not got the consent of the husband of this lady. So therefore, the court decided under the Tesavalami law, since a married woman cannot enter into a contract without the consent of the husband, the contract is not valid. That means the guarantee is not valid. So that is about the guarantees. So if you have any questions from guarantees and indemnities, you can ask now. Any questions from guarantees and indemnities? No questions.
So excuse me.
Yes.
There's a question.
Yes.
Just now you told regarding the Tesavalami law. Married
Yes.
woman cannot go for the guarantee unless the consent taken from his husband. Is it
Yes.
still applicable? The bank has to check that when they are going for a guarantee bond?
Of course, definitely. This is the law. This law is in existence in the country. Tesavalami law is there, right? That is our first lesson. You remember, under the sources of law, we discuss Tesavalami law, Candian law, Tesavalami law, and Muslim law. So these law principles apply. Tesavalami law applies even today. So therefore, if a Tamil lady gives gives a guarantee to the bank, so basically you have to see whether she is governed by Tesavalami law. If she is governed by Tesavalami law, then you have to get the consent of the husband. So basically what you have to do is your husband has to come and sign and give his consent to wife to enter into an agreement. Not only that, even to borrow money or enter into any kind of agreement, a Tamil lady who is governed by Tamil married lady who is governed by Tesavalami law has to get the consent of the husband. Or otherwise, if you don't get the consent, what will happen? That the guarantee will not be valid. The loan you can't recover because the loan agreement is not valid. So that law is there. Clear?
Sure, sir. Thank you. Thank you.
Right. Any other questions?
So what is the criteria to decide if that lady governed by the Tesavalami law or Muslim law or the normal law?
Right. Okay. So by looking at the name, right, this is where we do, right? Generally, by looking at the name and the identity card, you can see the person, whether that person is a Sinhalese person, whether that person is a Muslim or Tamil, right? So we will forget about the Sinhalese and Muslims. So we are talking about the Tesavalami law. So therefore, if a lady, if she is a Tamil lady, then you have to be careful, right? So now we have to see whether this lady is governed by Tesavalami law. If she is married, then especially we have to see, right? If she is married, you have to check, you have to ask from this lady whether you are governed by Tesavalami law or general law of the country, that is Roman Dutch law. If she says she is not governed by Tesavalami law and she is governed by normal law, that is Roman Dutch law, what you have to do is get an affidavit from her. If she gives an affidavit and say she is governed by Roman Dutch law, then thereafter she can't come and say that I govern under Tesavalami law. This, if it is so, if that happens, that is cheating, right? So you can take criminal action against that person. So that is how we have to do. So if that lady says that she is governed by Tesavalami law, then you have to get the consent of the husband. So that's how we do. Clear?
Does that mean the Tamil lady has a right to decide I should go under this law or I should go under Roman?
No. She has no right to decide that. Basically, it's applicable law, but you know under what law you are governed, right? So basically, you have to get a legal opinion also. You can't say that I am governed by, say I'm a Sinhalese person, I can't say that I am governed by Muslim law. I can't decide that. So the law will apply based on the law apply to me. So however, so in this scenario, we don't know whether this lady is governed by Tesavalami law or general law. So basically, this is not the only transaction this lady has done. She may have taken previously for loans, or she may have entered into certain land transaction. In all these occasions, if she has followed the general law, that is Roman Dutch law, common law of the country, that means that she has given up or she has accepted, she is governing under Tesavalami rather than not Tesavalami law, Roman Dutch law. So anyway, that we have to see whether she is where she has born, whether she previously has done transaction under Tesavalami law. Likewise, we have to see. But however, to safeguard the right of the bank, what we have to do, there's no other way that we can decide. So therefore, we take an affidavit from the lady. So then thereafter, she can't claim the nullity of the agreement based on Tesavalami law. So that's or at least then we can take action against the lady on cheating. So that's how we do.
Excuse me, sir, it's only applicable for the North women's and men, no, sir?
No. Under the Tesavalami law, you remember that we discussed it is applicable to the Tamils who Tamils of North and East. In the North province, and also the Tamils who are governed under Tesavalami law, if they live in the other part of the country, still they are governed by Tesavalami law. So therefore, there can be a lady who lives in Vellavatta who is governed under Tesavalami law, right? And their property is also governed by Tesavalami law, wherever it's situated. You remember that we discussed that under Tesavalami law. So if the property is in Colombo and it is owned by a lady who is governed by Tesavalami law, that property also then governed by Tesavalami law. So that apply to the Canadians and also Muslims also. Muslims, of course, property law is similar to the Roman Dutch law. You don't have to bother about that. But succession and other things that you have to be very careful. You have to see the personal laws also.
Sir, excuse me.
Yes.
Sir, Tesavalami law is only applicable for the Jaffna people only, right?
Jaffna Tamils, right? The Tesavalami law applies to the Jaffna Tamils. However, if the, for example, we say Mrs. Shivanyanam, right? We say she is living in Jaffna and is governed by Tesavalami law, right? And tomorrow she decide to come to Colombo and purchase a land in Colombo and live Colombo. Now, what is the situation? Whether Mrs. Shivanyanam now governed under Roman Dutch law? It is not, right? If she is governed under Tesavalami law, wherever she lives, whether she lives in Colombo, whether she lives in Nuwara or anywhere in the country, still she is a lady who governed by Tesavalami law.
Excuse me, sir. If she buy any land in the Colombo, whatever, out of the Jaffna,
Yes.
it will be coming under the Tesavalami law?
Exactly,
Or
yes. Yes. Right? So properties, if the owner of the property is governed by Tesavalami law, the property is also governed by Tesavalami law, wherever it's situated. I gave a case also. You read that. Remember? Under the Tesavalami note, you see, read it again, right? So to decide the person whether that person is coming under Tesavalami law applies to the Jaffna Tamils. So basically, Eastern Tamils, they can't, Batiklo Tamils, they can't claim they are coming under Tesavalami law because they are not, even though they are Tamils, they are not the Tamils who born in Jaffna district. So therefore, they are out. However, if a person who born in Jaffna and who is governed under Tesavalami law, and that person goes to some other area of the country and live there, still the law applicable to that person is Tesavalami law, right? It's different from Canadian law. Canadian law is different. You remember? Any other questions?
Excuse me, sir. Can a person change her own law? Like a person who is following Tesavalami law, can he like change for Roman Dutch law?
Yes, there it is possible. Now, for example, the person who lives, person who governed by Tesavalami law can give up that law and absorb into the common law of the country, right? If, for example, by conduct, that person can adapt to the common law of the country. She can if she doesn't practice the principles of law of Tesavalami, and if she follow the common law principles, then automatically that person can adapt to the common law. But person who govern under common law cannot acquire a personal law. Now, for example, say I am governed by common law, Roman Dutch law. I can't say tomorrow that I am governed under Tesavalami law or Muslim law, because a person who governs under personal law can give up the personal law and can come into the umbrella under the umbrella of the common law. Common law applies to everybody. So therefore, if you give up your personal law, you become a person who govern under the common law. In the other side, you can't do. So a person who govern under common law, you can't say that you are now governed by a personal law. Only the personal law that you can change is the Muslim law. You can anyone can be a Muslim by converting into the Islam. So if you convert to Islam, then you are governed by Muslim personal law. So that's only way. So other laws, of course, there are ways that that the person who can be a Canadian by marriage or Canadian by birth. Likewise, the person who a Tesavalami person can be by birth or by marriage. Apart from that, just by changing the law or by declaring that you have changed the common law, you can't come under the umbrella of personal law. But in the other side, other way that you can do, by practice you can give up your personal law and come to the common law of the country. Any other questions? Clear? However, yes.
Also, good evening.
Good evening. Yes. Yes, so please ask your question. Hello.
Excuse me, sir.
Yes.
So if one lady declares that I am not aware about whether I govern by Tesavalami law or common law, what would be the next step?
So then you have to obtain actually a legal opinion, because you can't decide. The bankers, the normal, general public, we can't decide the person's personal law. So then we have to get the advice of from a lawyer. The lawyer will consult the customer and will decide whether that person is governed under Roman Dutch law or Tesavalami law, based on the previous transaction done by this person, where he or she has bought, where he owned properties, when he is purchasing the properties, what is the law that he has followed previously, right? Likewise, that you have to see the history of the person and then decide what is the personal law applicable, whether he is coming under a personal law, whether he is coming under the Roman Dutch law, that is the common law. So that opinion that you have to get a lawyer and then decide the law. Clear?
Clear, sir. Thank you.
Right. Any other questions?
Sir, good evening.
Good evening.
Sir, I have a question.
Yes. What is it?
Shall I ask, sir?
Yes, sure. Ask your question.
When the Tamil people who lives in the hill country and she or he decided to live in the north side, or she or he can purchase a land in north side, then what will be the law? Law will be there to them. They will grant it to the Roman Dutch law or a Tesavalami law.
Right. Your question you asked, Tamil person who live a lady or we say lady who lives in hill country. We say Kandy, right? Or in Norelia. And she wants to purchase a land in Jaffna, right? So then what is the law applicable? Right. Person, Tamil lady who lives in Jaffna, in Kandy or Norelia, unless they born in Jaffna, they are governed by Roman Dutch law, the common law of the country. Clear? I repeat again. A Tamil lady who lives in hill country, we say Norelia, is governed by Roman Dutch law unless she is born in Jaffna. If she born in Jaffna, that means the Tesavalami law apply. That this can happen. No, a lady born in Jaffna, then moved to Nuarelia, now live in Nuarelia. So then she is governed by Tesavalami law. But we say this lady born in Nuarelia and her father, mother, and everyone were born in Nuarelia. And forget about her father and mother. This lady born in Nuarelia and lives in Nuarelia. So basically, she is governed by Roman Dutch law, not Tesavalami law, right? Then the question, she wants to purchase a land in, we say Jaffna territory. So you remember that we said the properties in lands in Jaffna area are governed by Tesavalami law. So law applicable to the land is Tesavalami law. The law applicable to this lady is Roman Dutch law, right? If she wants to purchase a land in any other place of the country, we say Batiklo. So she is governed by Roman Dutch law. The property also governed by Roman Dutch law. So if she goes and live in Jaffna, she will be governed by Roman Dutch law, not by Tesavalami law. Right? Clear?
Yes, sir. Thank you.
Right. So, any question with regard to the guarantees and indemnities? We are now talking about the personal laws. Anyway, if you have any questions, you can ask now. Or otherwise, I will go to the next topic because the time is limited. Okay, next one we are going to discuss is ubrima fide contract. Ubrima fide contract. This is a Latin word, Latin phrase. Ubrima fide means utmost good faith. Utmost good faith. Utmost good faith means that when you are entering into this type of agreement, ubrima fide agreement, you have to disclose everything, every important thing. So in other words, when you are entering into a contract, unless it is a ubrima fide contract, you don't have to inform all the information, or you don't have to divulge or give all the information. You may remember under the contract law, we said when the parties are discussing the terms and conditions before when we are exchanging information before we entering into the contract, the information that we exchange can be categorized into two categories: the important things and other things, right? But remember, if you are entering into a ubrima fide contract, it is the duty of the parties to disclose everything, every important things that they have to disclose, right? Guarantee is a contract. Guarantee is governed by Roman Dutch law. So bank has no obligation to disclose all information of the customer to the guarantor. Remember the guarantee, when it comes to the guarantee is not an ubrima fide contract. Guarantee is not an ubrima fide contract. Example for ubrima fide contract is insurance, right? If you take an insurance policy, if you have ever obtained an insurance policy, you may remember you get a big application form, right? There are more, I think more than 100 places that you have to tick. They ask everything, whether you have influenza, whether you have got any treatment for this thing, that thing, whether you have gone under, whether you have done any surgery before. Likewise, they ask 100 or 1,000 questions. And also, it is your duty to provide correct answers for all the questions that they have asked. If you have missed a single question, right, or if you have given a wrong, a misleading answer to any questions that they have mentioned there, it could tend to invalidate the insurance policy, because the insurance is a ubrima fide contract. Ubrima fide contract, right? So basically, ultimately the insurance company can say that we don't pay you because the insurance is not valid because you have provided a wrong information. We have asked whether you have undergone a surgery before, but you have said no. But we found that at the age of 3, you have undergone a surgery, right? That's a breach. You have given a wrong information, so therefore they can say that the insurance is not valid, even though you have paid all the installment, all the insurance premiums. Still, the insurance is not valid because it is a ubrima fide contract. However, when it comes to guarantee is not a ubrima fide contract. In other words, when you are entering into a guarantee, if you are taking a guarantee from a person, the bank is not obliged to inform or disclose all information of the borrower, right? It's not necessary. However, bank has to disclose that is because the guarantee is not a ubrima fide contract or utmost important, utmost good faith contract. But remember this case, even though we say so, this case is very important. Hamilton versus Watson. In that case, it was decided bank has no obligation to disclose everything to the guarantor, because under the guarantee we said it's not a prima facie contract. Therefore, the bank has no obligation to inform all the information of the customer, of the borrower to the guarantor, but should disclose unusual and unexpected features of the customer. Lord Campbell said the bank has no obligation to disclose everything, but important points or unusual things that bank has to inform. Otherwise, if they have not informed, the guarantee is not valid. Now, for example, we say we are going to lend the money to the customer, right? He's the borrower. He brings another person, a third party, who is the guarantor, who is willing to sign as a guarantor, right? We say now the borrower is borrowing, we say 10 million rupees. Guarantor, sometimes this happens, right? The borrower says, I'll bring my father, he will, or brother, that he will sign as a guarantor, but don't tell him that he is signing as a guarantor, tell him that he is signing as a witness, right? This is one thing could happen. Or sometimes they say, right, my father doesn't know that I am borrowing 10 million, right? He thinks that I am borrowing only 1 million. So if he asks, you tell it's only 1 million. Or don't tell how much I am going to, I am borrowing. So these things that borrowers, they request from the bank. We say we obtain the guarantor signature without disclosing that he is giving a guarantee for a loan of 10 million. What will happen? Right? If borrower default, then we go behind the borrower. Then after that, we go behind the guarantor. The guarantor can take the position as per this Hamilton case that the amount of the loan has not disclosed to me. So that is a breach. That the bank has a duty to disclose unusual and unexpected features. So 10 million is a big amount. So I thought that I am signing as a guarantor for 1 million. So this is unusual. So they have not informed me. Or sometimes we take guarantees when we are rescheduling facilities. Rescheduling facilities, we take guarantees. Rescheduling is non-bankers. Remember, rescheduling is when the customer borrow money, and after a while, that customer, if he can't pay the installment, he requests the bank to reschedule the facility. So what we do is we reschedule the terms and conditions, and we reduce the monthly installment by expanding the loan period. So likewise, we can do adjustment to the loan. That is called reschedulement. Well, when we are doing reschedulement, sometimes we ask customers to bring new guarantees. So we say now a customer brings a guarantor, and the guarantor is under the impression that he is signing as a guarantor for the new facility grant to the customer. Actually, it is not a facility that grant. It is a facility already granted, and the customer has defaulted, and now we are rescheduling. So that is an unusual feature. So the bank has a duty to inform the customer that he is signing as a guarantor, and also he is signing as a guarantor for a rescheduled facility, not to a original facility. Likewise, the bank has an obligation to inform the unusual and unexpected features of the customer as per the Hamilton case. And there is another case, that important case, Mackenzie versus Royal Bank of Canada. In there, the court said contract of guarantee, likely any other contract, is liable to be avoided if induced by material misrepresentation of an existing fact. One side, the bank has a duty to disclose unusual and material facts of the customer to the guarantor. The other side, the bank cannot mislead the guarantor. For example, the customer say, I am bringing my father to sign the document. He doesn't know that he is signing as a guarantor. I have told him that he is signing as a witness. You also pretend that he is signing as a witness. Don't tell that he is signing as a guarantor. So if you obey to the customer's instructions, and if you misrepresent the fact that he is signing as a witness, that guarantee bond will not valid in court of law, or he can challenge that in court of law. So that is about the prima fide contracts and guarantees. If you have any questions from this, you can ask now. Any questions? Okay, so then if you don't have questions, with this we'll finish the securities lesson. Then we'll go to the next one. Right. Next, we are going to discuss about this, the debt recovery laws. Can you see the screen? I believe that you can see the screen.
Yes, sir.
Right. Okay. Thank you. I think this has been shared before, so by the institution. Okay. Next, we are going to discuss the special debt recovery laws. Right. The first slide I have given this all. I have discussed previously also. When we take the banking facilities, there are two types of facilities, that secured facilities and unsecured facilities. I have given some example for those secured facilities and unsecured facilities. A secured facilities example, facilities secured by guarantee bond, FDs, mortgages, pledge loans, leasing, hire purchase. Those are secured facilities. Unsecured facilities, example, casual overdraft or temporary overdraft, short-term loans, credit cards. So whatever the facility we provide without a collateral. So then we'll see the debt recovery process. You remember granting of loan and recovery of loans both are equally important to the bank. Now you may remember under the banking law we discussed under the banker's business, our core business is lending money, right? We take deposit from the public, right? On a condition. What is the condition? We have to pay that money on demand to the customer. That is how we receive money. Then our business is we lend that money. How we generate income? We lend money on interest. So therefore, remember, we are lending customers' money, depositors' money, not our money, not banks' money, directors' money, or shareholders' money. It is the money deposited in the bank by the customers or the depositors. The bank has an obligation to pay that money back when customer or the depositor demand. So therefore, we should have a mechanism to recover that money that we lend to the borrowers effectually, or otherwise what will happen, we will not be able to pay the depositors when they demand. For example, we say we have 10 million, we take, this is just an example. We say that the total deposits of the bank is 10 million, right? The depositors' money deposit in the bank is 10 million. Now we have agreed to pay 10% on these deposits. So basically then at the end of the year, we have to pay the depositors 10 million plus 10% of 10 million. That is another 1 million. 11 million that we have to pay at the end of the year. So now we have to generate income. Otherwise, we can't pay 10% interest. So how we generate income? We lend this 10 million to the borrowers. We say we lend 10 million to the borrowers at the rate of 15% per annum. 15% per annum. We say we gave 10 loans, 1 million each, at 15% interest rate per annum for 10 borrowers. 10 borrowers. Now, what will happen at the end of the year? We say we recovered all 10 loans with 15% interest. Then what is the income of the bank? We recover 10 million plus another 1.5 million. So we have to pay the depositors 10 million plus another 1 million. So 11 million. Then we have 5 lakhs profit, right? So this is if we recover all loans, all 10 loans, we'll assume that one loan went bad and we couldn't recover. So now what is the situation? We have granted 10 loans, 1 million each, right? At the end of the year, we recovered only 9 loans. So 9 million capital we recovered, right? Plus interest for that 9 million. Now, can we pay the debtors, so rather the depositors? Depositors, we have to pay 11 million. We don't have money now. We are in cash flow problem. So therefore, the bank and the financial institution should have a mechanism effective mechanism to recover their loans. So how we recover the loan? If customer default, what is the mechanism that we can adopt to recover the loan? We know that the banks, before we go into litigation, before we go into courts, we adopt certain methods, right? The bank officers try to recover. They contact the customer, they visit the customer, they collect money from the customer. If it is not happening, then we give to the agencies to recover. So the outside companies, then they visit the customers, they bring the money. If that is also fail, then the last option that we have to take legal action. So basically, we have to go to courts and file action. So we'll see what is the procedure that we have to follow in court of law. This is very important to the bankers because lending is not the only business or only work that the bankers has to do. The recovery of lending also is a very important part. So bank officers, they should be aware the court procedures also, because the bank officers has to go to courts and give evidence and participate in court cases also. That is a part and parcel of their job. So therefore, knowing this procedure, court procedure, is an advantage for the bankers, right? So we'll briefly discuss the court procedure to understand the process at the court. Right. So first one we are going to discuss is district court regular procedure. Right. When a customer default, so under if it is a loan or overdraft, or if it is a loan backed by a guarantee bond, this is the procedure that we apply. So what we do? First, we send a letter of demand to the customer, right? After sending all the reminders, after visiting the customer, after trying to collect the money, if it is not going to work, then what we do, the file will be transferred to the legal department. Then the legal department, they start the legal process. The first step of the legal process is send a letter of demand. The letter of demand is sent by a lawyer. So basically, in the letter of demand, we demand the customer to pay the total outstanding and the interest, the capital and the interest, both within 14 days from the date of the letter, right? That is the legal demand. If customer doesn't meet the demand or not pay as per demand, then bank has a right to file action. Bank has a right to file action against the customer. Unless you send a demand, you don't get that right. So that is why the letter of demand is very important. So letter of demand, it has to be accurate, right? You can't time to time change the or withdraw the letter of demand. It has to be very accurate one. So therefore, we have to be carefully draft the letter of demand, because it is the first step of the litigation process. Then, if the customer doesn't pay money as per the demand, we filed action in court of law. Filed action. Filing of action means, what are the documents that we file? We take example bank. We say we have granted the loan to a customer, borrower, and there is a mortgage. There is a guarantee bond signed by the guarantor, right? So what we send a letter of demand first to the borrower and also to the guarantors. Then we filed action against the customer. So filing action means we filed a motion. Lawyer prepare a plaint, and together with the plaint, we file marked documents and proxy. Proxy is a legal document where the banks give authority to the lawyers to appear and file action on behalf of the bank. The marked plaint is the is the complaint that we made to the to the courts, that is in writing, in written form. And marked documents means the documents that we mark in the plane to support the complaint. Now, for example, if we say now the normally plane says so and so is a customer of the bank, and he obtained a loan. He asked for a loan. He requests for a loan. Then we mark the loan application to support that statement. So then we say his loan application is marked as X to the plane. Then we say after considering his loan application, bank issued an offer letter to the customer. Then we mark the offer letter as Y or whatever, right? Then we say the customer accepted the offer letter. After accepting the offer letter, bank and the customer entered into a loan agreement. Then we mark the loan agreement. Likewise, all the necessary documents we annex to the plane. Those documents are called marked documents. Then it is important, there is an important point I have raised here, the jurisdiction and the prescription. This is very important to the bankers also. Jurisdiction means that the place where we can file the action. The place where we can file the action has to be decided by the legal lawyers, right? So there is a mechanism that there is a process that we can determine the jurisdiction. It basically can be decided on the residential address of the borrower, or where you have entered into the agreement. So likewise, we can decide, the lawyers can decide the jurisdiction. The other one, the prescription period, is very important, especially to the bankers. Because remember, there is a prescribed period as per the law to file action. If you don't file the action within the prescribed period, your right to file action comes to end. So that means that no action can take against the customer thereafter. Right? If I say simply, if it is an agreement, if it is a written agreement, if the transaction is based on a written agreement, we have 6 years from the date of the breach of the agreement, if it is a written agreement. If it is not a written agreement, verbal agreement, example, casual overdraft, right? If it is a verbal agreement, we have only 3 years from the date of the breach. Date of the breach means from the last date of the payment. So therefore, the bankers, bank managers, assistant managers think about this, right? Don't keep the files, non-performing files, in the branch or department for a long period of time. What will happen? If you keep the files, if you hide the files in the branch or the department without sending that to the legal department to take action, the action can be prescribed. So thereafter, the bank will not be able to file action against the customer. So therefore, it is very important to file the action within the stipulated or prescribed time period. So that must remember. Then after filing the action in court of law, the court issues summons to the defendant. Summons, we say in Sinhala we call this sitasi. You may have heard this, you may have seen this, right? So summons issued to the defendant. Defendant means the borrower and the guarantors. When summons served to the defendant, that is the borrower and the guarantor, they can come to the courts and file their answer in the court. Answering to the complaint of the complainant, that is the bank, right? Summons issued, summons served to the customer comes and file his answer. Now after filing the answer, the matter can then fix for trial. So there is a complaint now. There is an answer filed by the borrower and the guarantors. Now the matter has to fix for trial. Matter has to trial and decide. So then the court will fix the matter for trial. So before the trial, the parties, that is the borrower and the bank, both has to file their list of witnesses and documents. List of witnesses mean the number of names and the addresses of the witnesses who give evidence in court, and also the documents that they are going to mark at the trial. That documents list and the witnesses list we have to file in court of law before the trial, before 15 days of the trial. Then after that, the matter will be taken for pre-trial. Before the trial, there is another step called pre-trial. At the pre-trial stage, the court will see whether the parties can come into a settlement. So, sometimes after we filing action, after we, when the matter is fixed for trial, the parties come and say, especially the borrowers say that if I get a chance, if the bank gives a chance, that I am ready to pay if I get time. So likewise, the parties can discuss and decide, come into a settlement at this pre-trial stage. If there is no settlement at the pre-trial stage, then the matter will fix for trial. So trial means the parties have to come and give evidence. In a trial, first the plaintiff has to start the case and give evidence in court of law. So plaintiff in this matter is the bank. So therefore, the bank officers now has to come and give evidence. So that's why I said it is very important to know the procedure, court procedure, because it's a part and parcel of the banker's job. So then the plaintiff case, after the plaintiff case is finished, then the defendant case starts. So plaintiff evidence, that is the bank officer's evidence, they have to come to courts and give evidence. When you are giving evidence, there are three stages there. First stage is called examination in chief. Examination in chief means your lawyer first question you. Then after that, there is another stage which is called cross-examination. Cross-examination means the other side counsel lawyer, that is the borrower's lawyer and the guarantor's lawyer, can cross-examine you. So after cross-examination is finished, then again the bank lawyer can re-examine the witness, the bank officer. So he can ask question again. Likewise, the plaintiff, that is the bank, they have to give evidence. After all the bank witnesses give evidence, then the customer and the borrower can give evidence. So then our lawyer can cross-examine the customer. So then after that, and also when you are giving evidence, we can mark documents also. So the documents you can, when you are giving verbal evidence, the same time your lawyer can mark the documents. For example, if you say the banker and the bank and the customer entered into a loan agreement, then the lawyer can mark that loan agreement at the trial. So after that, after all evidence being taken, then thereafter there's a stage called a written submission. That is the lawyer, both side lawyers, they have to summarize the case and they have to give their submission in written form. Basically, what are the laws applicable, what are the cases applicable, whatever the law principles applicable, all these things that we basically the lawyer's argument that he put into the written form in writing and tender to the courts. Both side lawyers, they do that. That is called written submission. Now the case is finished. Basically, the trial stage is over. Now, after the trial stage, then the judge will look into the plaint, looked into the answer, looked into the documents, looked into the evidence laid in the courts, and the written submission filed by the lawyers. Then he will pronounce the judgment. That is step number 9. We say the judgment is in favor of the bank. So that means the judge has decided the bank has a right to recover the money from the customer. So that judgment is given. Then how do we recover the money? Now judgment is just a paper, right? Judge sign paper, right? So then how can we recover the money? So then after the judgment is given in favor of the bank, there's another step called execution of decree or execution of judgment. Execution of decree or execution of judgment means the court officer, there's a court officer called fiscal. The fiscal officer can seize the properties of the borrower and the guarantors. Basically, he can seize the electronic or electric items and other valuables of the borrower, vehicles and everything, lands, everything that he can seize. So after seizing that property of the borrower and the guarantor, the fiscal can auction the property by a public auction, basically. So the fiscal officer will auction the property. After auctioning the property of the borrower and the guarantor, the fiscal will bring that money that he collected from the auction, and that money can be utilized to recover the loan of the borrower. That is the procedure that we apply in court of law, which is called regular procedure to recover money that we lend and defaulted by the borrowers and the guarantors. So this is the regular procedure in court of law, district court that we follow to recover the money. So if you have any questions from this process, or if you have any, yes.
Excuse me, sir. Just needed to get a clarification. When we sending the letter of demand, if customers say I'm not positioning to pay off within 14 days, but anyhow I need a time within a 6 months or some kind of thing if we request. So bank, what will bank do?
It's actually a decision that bank officers has to make, because you see, even you go to courts, if you file action, you can't finish the case within 6 months time. Normally in a regular action, regular money recovery action under this process, it takes 3 years to 4 years to get a final result. So therefore, if customers say that I can't pay within 14 days, but I can pay within 6 months time or even 1 year time, it's a call that the bank has to make. So basically, still it is worth to go for a settlement, outside court settlement, and give him a plan in the sense a settlement plan. Advice is get that consent in writing. Ask the customer to write to the bank. Right, first thing is that when you send the letter of demand, basically customers they run to the bank and they discuss with the bank. They say, okay, I agree that I have to pay this money. I am not a willful defaulter, but I need time to pay. So what you have to say is, okay, if you say he say I want 6 months, right? You say, right, we will consider your request, but you have to give your request in writing. So then basically he accepts his liability, right? That's it. That is very important. In case he defaults the settlement, that document, that the letter that he signed can be used in the litigation process against him. So therefore you get that in writing. Then thereafter give him a plan, a repayment plan or settlement plan. For that, you enter into agreement, you give offer letter, you sign the agreement and ask him to pay after that. So if he default the agreement again, then you get a new course of action. So after defaulting the settlement, you can file action. So that is one way that you can do. or if still you think it is not worth to give him a chance because he is a willful defaulter, he just try to postpone the recovery process, then of course you don't have to consider his request for the settlement. If he failed to pay within 14 days, the bank can decide file action straight away. So those two options are available basically. Clear?
Okay, thank you, sir. Thank you very much.
Yes. Any other questions?
So what is proxy, sir?
Okay, proxy, I briefly explain you. Proxy means, now you see now the plaintiff in this matter is a bank, right? Even now the bank is the plaintiff, but the documents and the other documents are signed by the lawyer, not by the bank, right? So what is the authority that the lawyer has to appear on behalf of the bank? So we give the bank or the customer or the borrower or the client gives the authority to the lawyer to appear on behalf of him by signing a proxy. There is a document called proxy that the customer has to sign. So if banks gives authority to a lawyer to appear on behalf of the bank directors, two directors of the bank has to sign this proxy and give the authority to the lawyer to appear. It's like the customer gives a mandate to the bank to operate his account on behalf of him. So that is called mandate, right? Here, the authority given by the client to the lawyer is called proxy. That proxy is in written form. There is a format. So the customer sign and give the authority to the lawyer to appear in court of law on behalf of him. That is called proxy.
Sorry.
Clear?
Thank you, sir. Yes, sir. Sir,
Right.
this trial, sir. What is the meaning of trial? What happens in trial?
Trial, of course, I explained to you. At the trial, now there are two parties, plaintiff and the defendant, the bank and the borrower. Bank has filed a complaint and the borrower has filed answer. Now judge has to decide who is correct or whose story is correct. So he has to decide that by going into a trial. Trial means the plaintiff, that is the bank, and the defendant has to prove their plaint and the answer. How do they prove? They prove by giving evidence at the trial. So you may have seen this. You go to courts, that is the officers of the bank, they go to courts, then they put into that witness box and your lawyer first asks question from you. Then after that, the other party lawyer cross-examine you. Then again, your lawyer re-examine you. So while asking question that he can mark the documents also. Basically, the lawyer asks whether this person is a customer of the bank. Then you say yes. Whether he maintain an account with the bank, you say yes. Whether he signed a mandate, you say yes. Then he say, where is the mandate? Then you produce the mandate. He mark the document as X. Then he say, did he apply for a loan? You say yes. When? Likewise, then he asks. Then you say, do you have the application? You say yes. Then your lawyer get the application and mark as Y. Likewise, the evidence will be taken. Then thereafter, the other side lawyer will cross-examine you, right? He will ask, at the time of signing the loan agreement, were you there? You say no, right? Then he will say, in this document, you have not signed as a witness. You say no. Likewise, then you cross-examine. After that, your lawyer re-examine you again, right? Then he asks, do you know? Can you identify the signatures of the witnesses? That you say yes. Are they bank officers? You say yes. Likewise, re-examination. Then after that, after the evidence is taken, evidence are taken by both parties. Then thereafter, judge will decide based on the evidence given by the bank and the other side, in whose favor the judgment should be given. It could be in favor of the bank. It could be in favor of the borrower also. Clear?
Yes, sir. Sir, now if you are going for execution of decree, and
Yeah.
if there are no assets to be seized, I mean, if it's not worth the, if there's no not much of assets, then the case has been lost, no? So
Yes, that is why that is a practical problem that we have. That is why we always say when we are lending, you have to correctly evaluate the creditworthiness and the capability of payment. So you have to get you normally get a asset declaration of the borrower and also asset declaration of the guarantors. So basically you have to check whether he has enough or sufficient properties in case of default. So if there are no sufficient properties of the borrower, then you have to get the guarantors. You get the asset declaration from the guarantors. If one guarantor is not sufficient, you take 2, 3 guarantors. It depends. So basically, if borrower's properties are not enough, then you go behind the guarantors, you seize the guarantor's property. Then if the first guarantor's property is not sufficient, you go behind the second guarantors. Likewise, you can seize the properties of the borrower and as well as the guarantors. If guarantors also does not have sufficient property, then it is a loss to the bank, even though you have win the case.
Excuse me, sir, in this case, why can't we get the bank assurance?
What do you mean by bank assurance?
No, when we lending the loans,
yes.
So we always take the insurance, no, the mortgage insurance. So why can't we use this when we default?
Yeah, if now here we are talking about a loan facility and overdraft facility backed by a guarantee bond, right? If it is a mortgage property, then loan protection is there, but loan protection insurance is there. If customer deceased, only they pay, right? So if they default their loan, the insurance they don't pay. I don't know. There is no insurance to protect the bank from default of payment. But if customer deceased, there is a protection.
Okay, sir. Because that was my doubt. Anyway, thanks, sir. It's clear now.
Right. Okay. Any other questions?
So, excuse me, sir. This question refers from our previous class one. There is a issue in regard to a limited liability company when the board of directors previously they have submitted to the bank is usual, and once the another company is collaborating with that particular company and they have changed the board of directors.
Yeah.
Hence, the company secretary of the current company secretary have not declared the change in board of directors and new positions come ahead. In this point of view, sir, is we are covered by the law once if they are not submitting to us the change in board of directors, or how this is how the bank is safe mood in regard to a law, or do we have to talk with the particular company secretary just to push them and take the declaration and all?
First of all, tell me whether you have granted facilities to this company.
Yes, sir. The facilities have been granted. Who have been signed at are the directors. I mean, the board of directors are the current persons have been signed and all.
Right. Current directors, they have signed to the documents, but they have changed their directors, but it is not informed to the bank. That is your question, no?
Sure, sir. Sure. That's what.
Right. Okay. So if the secretary doesn't provide that information that you can obtain from the registrars of companies, right? There you can do a search and you can get the information of the change of directors information available there. You can apply as a lender. You have a right to apply and you can get the information. First, you have to get write to the secretary and ask the secretary to provide this information. If the secretary does not provide the information, that you can get that information from the ROC, registrars of companies. There's a format for that. You can go and do a search, or even if you don't, I don't think that you are aware to how to do this. So send a lawyer or known person who knows the process there and get that information. It is important to keep that information with you because you have already lent money. If there is a dispute in this company, then you can see who are the directors, and you can sometimes, if the company misuse the funds or the funds of the loan, you can go against the directors also under the Companies Act. There's a provision for that also. But for all these things, that you should know who are the present directors of the company, and you should be available with that information. Therefore, it is important to obtain that.
Okay, sir. Thank you. Once again, sir, the thing is, it's like not the previous directors are also there. Hence, another two people has been added on, and the chairman, I mean the board of directors, the chairman has come. It's like a COO, and that's how it acts on. But he is also the previous director is also on the pace now. But
yes,
it's not officially they have informed to us the change in board of directors, and also what other company has been has been collaborate with that, and also in this period it's like an unofficial matter. Just we got to know that they have been gone for a collaboration. In this point of view,
right.
sir, do we have to back on them and ask them and to get out the information?
Have they changed the name of the company?
No, sir. It's as usual the same.
Right. Okay. So then the bank is safe. If they have changed the name of the company, then you have to be careful. Then you have to get the name of name change information also from the ROC. Now you said the previous directors are there. Now they have increased the number of directors by amalgamating another company or collaborating with another company. So the new people they have come to the board of directors. It doesn't matter. It's no legal harm, but it is important to have that information in your hand because you have lent money to that company. So therefore, you write to the secretary and get the information, the change of directors, and if it is failed, then you can obtain that information from the ROC. But since the name has not been changed, that means the company is still there, existing. So therefore, the bank has no risk, actually, no high risk there at the moment.
Thank you, sir. Thanks a lot.
Right. Okay. So now it's time, I believe, 3:22. I believe you have another class. So we'll stop at this point. So then we'll start on the next day from hypothetical action, that is mortgage bond action. From here, we'll start on next Saturday.